I think, no, I said the bell seemed like a new feature, so I wasn't prepared. I felt like I've been being called to church or something. All right. See you. All right, if we can get everyone situated, we will get started. Terrific. Welcome to our wireless spectrum panel. I'm thrilled. I thought the last two panels did a great job of setting up our discussion and really teeing up some interesting points for follow-on. So I'm thrilled as well to have a really terrific panel here joining me. And we've agreed that we were going to start off with a general discussion of what folks' background are, their organizations, and what the perspective is they bring to Spectrum, since many of you are not Spectrum people. And so we're going to start with that, and then we will go from there to a series of questions and hopefully get some questions from our audience as well. So Rob, you want to kick us off?
Sure. So I'm currently at CableLabs, and cable operators are doing a lot in Wi-Fi right now, which of course uses unlicensed spectrum. But I've seen spectrum property rights from all angles, really. Before CableLabs, I was at the FCC, where in part I was helping to design the incentive auction program, which is a situation where you have pretty clear property rights and you're setting up a new market to trade those. And before that, I was at the White House Office of Management and Budget, where I had a pretty broad portfolio and dealt in part with federal spectrum. One of the things I did was move the AWS-1 band from federal to commercial use, and I'm starting to actually feel a little bit dated now that we're on AWS-3.
4 even.
Yeah, 4 already happened, didn't it?
Yeah.
So I've kind of seen it from all angles, and what I've learned over time is that there's really room, I think, for different models in terms of property rights, where you have clear rights in the case of spectrum licenses that are issued by the FCC, somewhat fuzzy property rights in terms of the federal agencies, and little to no rights, at least legally. David might correct me in terms of the politics, but in unlicensed spectrum. And I don't think any reasonable observer of spectrum policy would say that we can do away with any one of those three. So I think there is room for all three. It's really just the balance between them, and I'll leave it there.
It's particularly spectacular to have Rob on the panel because I'm not sure anyone actually has the background that you have, having been at OMB and at the Wireless Bureau and now working at CableLabs. It's really a terrific combination of perspectives to bring to this discussion. So we're particularly glad you could join us. Bob, you want to go next?
Thanks, Brian. I'm Bob Kelly. I'm a partner with Squire Sanders, which is a law firm, and I have practiced in the area of telecom for a number of years, and for maybe the last 25 or so, almost exclusively on spectrum issues. My perspective, and I admit after we had our call, I had a little identity crisis trying to figure out who I am.
That's what those prep calls are
but it was
for,
good.
Bob.
It was productive. It was productive. My perspective is, I mean, I don't really work a lot with the AT&Ts of the world, the big broadband spectrum. I work more with more specialized types of uses. For example, the intelligent transportation folks who have some issues with the 5 gigahertz band now. Someone mentioned the Progeny case. That was one of our cases from the prior year. But I also I've worked a lot with spectrum rebanding. I've been part of the 800 megahertz rebanding project for, it's a 3-year project, and we're past that by a few years now. So I guess specialized spectrum is a little bit more of my perspective than just the big carriers.
So Bob, just to flesh it out for folks who are not spectrum people in the room, maybe pick one of those, whether it's Progeny or 5 gig or what have you, and just sort of talk about the tensions between the property rights that were implicated in there and sort of to give people a better feel for what those debates are about.
Sure. Well, let's take the 5 gigahertz band. As I'm sure most of you know, or some of you probably know, the 5 gigahertz spectrum has become a very hot topic these days because the unlicensed community particularly has identified that as a terrific home for next generation of what they do, broadband channels, 160 megahertz channels, to allow, among others, cable access on a more robust basis, to continue the great things that the unlicensed community has done with that. There's some incumbent users in the band and other plans for use of the band. One of them is a licensed service at 5.9 gigahertz, which is for dedicated short-range communications. It's a roadway to vehicle infrastructure. It's part of a or it's related to a U.S. DOT program for intelligent highways, intelligent transportation, and the idea with that, of course, it's used for improving safety in the surface transportation and particularly saving lives. So it's a pretty interesting case right now in terms of potentially conflicting uses between licensed and unlicensed in that band.
What's particularly interesting in light of the last conversation where we talked a little bit about mineral rights and rights jumping and I mean DST, what is it?
DSRC.
RC. I was there when we, the allocation is now more than a decade old and has not been a ton of deployment. Is that fair?
It's fair. It's fair that there's not that there are some systems out there. There's not. They're not nationwide, and the program has been pretty much continuous since the spectrum allocation. It actually raises some interesting spectrum issues
Yes.
about long-range spectrum planning. I think. I mean, that's one of the perspectives. One of the issues I actually wanted to raise was how long range do you have to have spectrum planning? Because there are a lot of technologies out there, and if you want to develop them, they may need to have some assurance of spectrum available in 15 or 20 years. And how do you do that?
Rob, how do you look at this debate? Do you have a view on this particular 5 gigahertz matter?
Absolutely. So, I think one of the things that's a developing area in spectrum policy is what does spectrum sharing mean? It's often looked to, I think, as a panacea for how are we going to facilitate wireless broadband going forward, given that clearing and auctioning exclusive use spectrum is somewhat hard to do and takes a long time. So people, I think, may tend to easily default to let's just share it and it'll be a lot easier to all achieve our goals. But really the devil's in the details in terms of how that sharing is achieved and how the rights are parsed. I'd look at it from the perspective of, in the first instance, we need to make sure that sharing is done in a way that really allows the full utility of the spectrum to come through, and that often requires hard technical work to know what the interference risk is. And so, in terms of this 5 gigahertz issue in particular, in a different part of the band, the FCC actually just took some action in this regard on Monday to expand bandwidth at 5 gigahertz by doing some of the hard technical work to figure out the interference risk, really without diminishing the rights of the primary user, which is a satellite company by the name of Globalstar. I think that's a great example of where the FCC can really take a hard look at where can we sort of increase flexibility in the paradigm of spectrum sharing to make sure that it's fully used.
Great. So I guess we'll go to Joan next and get your perspective, and then we'll start diving into some more of the issues. Joan?
Thank you, and thanks for inviting me here for this conference. Very interesting. I had much the same reaction that I think David did, which is we don't traditionally have a feeling that we have property rights in our spectrum. We have licenses. But this conversation has been so interesting, and I'm seeing so many analogies being drawn that I think are so apt, particularly when you talk about trying to reform a system like spectrum licensing. So I work for AT&T. I'm the vice president of federal regulatory, and we spend a lot of time worrying about spectrum. Without spectrum, we cannot provide services to our customers. And our customers are demanding more and more bandwidth all the time, and that requires that we build deeper, denser networks and add more spectrum to our portfolio just to keep up with the demand being driven by all the devices today. So traditionally, of course, we've relied on licensed spectrum, and we put an enormous value on licensed spectrum. We've spent billions of dollars to acquire licensed spectrum and billions more to invest in licensed spectrum to build our networks. We view licensed spectrum truly as the bedrock of our network and our portfolio, spectrum portfolio, and also view that the rules really should very specifically protect those rights and have renewal expectancies around them because of how important it is to our services and the investments that we've made in license. That being said, we also rely on unlicensed. So every device that we put out there, almost today, all new devices at least, have Wi-Fi clients on them. and more we are making those Wi-Fi clients smarter and smarter so phones can detect Wi-Fi when it's available to try to take some of the data capacity off the macro wireless network, which relies on licensed spectrum, and backhaul it very quickly. Wi-Fi takes it very quickly to a wired infrastructure for backhaul, and that helps us handle capacity, particularly the types of data demands that we're seeing today. So we do rely on unlicensed as well. I think as somebody indicated, unlicensed is only as good as how many people you're sharing it with. And if you've ever been in a convention in Las Vegas and tried to turn on Wi-Fi, you know exactly what I'm talking about. It's useless. It's in the commons. The more people that are there, the less use is driven by Wi-Fi. And so that's why we very much applauded efforts by the commission, the Federal Communications Commission, to bring more unlicensed bands to bear. And I also agree that not all licenses are created equal. From a license perspective, for our macro network, we are pretty much stopped at about 3 gigahertz. Above that, the characteristics of the spectrum do not make it useful for sort of a high-power macro network. Those bands are very good for the type of low-power unlicensed applications, Wi-Fi-like applications. And so that's why we've seen a lot of development above 3 gigahertz by the FCC on unlicensed, and we're very supportive of that. We're also very supportive of some of the, I think, thought leadership coming from different corners, particularly from Bill and Pierre from this school on spectrum reform. Just because so much spectrum, and this goes to sort of the interesting question on the last panel, where somebody said, if a well was drilled 30 years ago, is it still operating at an efficient level? Or is the technology so old that it's no longer efficient? Well, if a license was allocated 30 years ago, is the efficiency of that license, does that still make sense? And I think what we're finding out from both a political perspective, from a regulatory perspective, and I think from a social perspective, talking about some of the social goods also addressed in the last panel, we're finding out that certainly the demands of the country have changed, the demands of consumers have changed, and some of those allocations may not be so efficient anymore. Changing them, however, is an enormous challenge. And I think it's very interesting to look to the history in mineral rights and in water rights, and maybe some of the struggles and some successes and failures we've seen there as we try to struggle through spectrum reform. And I think Brian's going to get to questions about spectrum reform. So, but that too is something that we think a lot about, and I really like to engage in this debate.
So you touched on efficiency. So can we talk a little bit about AT&T's incentives to be efficient, and then maybe compare and contrast that with other licensees' incentives to be efficient?
So our efficiency really is driven by our customers' demand. We must be efficient with our spectrum to be able to put the type of capacity out there that's needed today. So we are really working to try to squeeze every bit of efficiency out of our spectrum, and we do that in a number of ways. Number one, we keep improving with better technologies. So as new technologies come out, the most recent technology is something called LTE, or LTE Advanced. It's more efficient in terms of capacity and throughput, and it's greater speeds. If you have an LTE device in your pocket, you know. You saw the difference between that 4G technology and the prior 3G technologies that you carried. And we're also doing it, as David said, spectrum's infinitely renewable. And it's renewable in terms of how densely you build your network. So we're doing it by continuing to build denser and denser networks. We not only have our cell towers, but we're now doing small cell builds. We're doing distributed antenna systems in arenas and other common areas, and all that's to build a very dense network, so we're using spectrum channels very, very frequently and reusing them very frequently. So we are really driven by the customers that we serve and by the economics of our business to be very, very efficient with our spectrum. Other users are not so much so, just because the government users don't have a profit and loss statement. And their user base looks very different. So if you have spectrum that's supporting a mission-critical military system, maybe that system's not on day and night. But when it's on, you need it to work. And we certainly understand that. So you cannot use the same measure of efficiency across the board. But part of the problem is the federal government, of course, is one of the largest licensees of spectrum. They have enormous allocations, and there is really no efficiency test at all for the federal government. There's really no economic incentives. And very little, I would say, consumer incentives. They have to serve their base, but there's no requirement that they get the most efficiency out of that, out of their spectrum portfolio, and like I said, it's a very significant spectrum portfolio. And that's been one of the biggest challenges of reform. So when we look at government spectrum, we talk about reallocating government spectrum, or even potentially having commercial users share with government users, how do we protect the incumbent systems that we have to protect? What rules of efficiency should we try to impose on them? And who judges? So much of this is national security and it's behind the veil, so it's very difficult to understand what they're doing. And we understand that too. We understand the national security concerns. So who judges that? And then how do we try to reform those allocations, many of which are like the 30-year-old well that was drilled with technology 30 years ago? And I think that's one of the biggest challenges being faced right now by the industry and by the government.
So before I bring Pantelis in, I'm going to be brought back in on efficiency as well. Maybe two other licensees, broadcasters, how efficient are they? And satellite users. So we'll have a nice pivot off to Pantelis after that one.
So, I mean, the broadcasters are, and I think this is addressed a little bit, there's rules by which they have to play. So they were all allocated more than 30 years ago, a 6 megahertz channel. And the FCC very specifically tells them how to broadcast over that channel. And they say, take your signal and spread it over all 6 megahertz to deliver a broadcast signal to this population of people. And it's all very, very tightly defined. These rules are from the 1950s. You can well imagine broadcast technology has changed a little bit since the 1950s. And even though the technology updates, the standards haven't really updated with it specifically or to reflect current technologies. And so the feeling is, and by the way, the community served by over-the-air has continued to shrink. In the 50s and the 60s, it was, I don't know, 70%, 80% over the air. Now in cities like New York, 6% of the population gets a signal over the air. So you can see this huge change in terms of how the spectrum's used, who it serves, and an argument about whether they're even using it efficiently. I think we struggled with this as an industry and as a government for a long time until David and his colleagues passed this legislation a year and a half ago, 2 years ago now, that set up this whole new regime to create incentives. Economic incentives for the broadcasters to say, voluntarily, no one's going to force them, we don't need the spectrum anymore, we're prepared to surrender it so it can be used by somebody else. And then the wireless industry would come back and say, we do need the spectrum, and we'll pay for it. And you can use our money that we're going to use to pay for it to pay the broadcasters to get out. Very, very complicated experiment underway here. Nobody in the world has done this type of two-sided auction. We're certainly very engaged in this, and it remains to be seen where it goes and whether it works. But one example of really innovative spectrum reform to try to get to the very, very tough question of how do we deal with these decades of allocations.
Satellite, real quick. How efficient?
Well, I want to take a couple of steps back.
You're going to get back on first, absolutely.
Before I get to satellite efficiency, I want to duck your question, Brian. Hello, everyone. Thank you for having me. I'm Astepto. I'm head of the Telecom, Internet, and Media Group there, and I represent clients who have spectrum rights or claim spectrum rights or dispute the spectrum rights of others. But I wanted to take a step back, and I agree, by the way, with I think everything. I was surprised to find that I agree with everything that has been said so far. But I wanted to take a step back and go to something that you may find initially whimsical, but that I think is at the heart of all the problems that were mentioned, whether they go to the fuzziness of rights to the spectrum or whether they go to the lack of motivation on the part of the government to be efficient. This is a statement made by then Chief Justice Taft, William Howard Taft, who had been a president. He was Chief Justice in the 20s. And he had this to say about spectrum law, which was then called radio law. He said, I've always been able to dodge that question. Why? Because interpreting spectrum law is like trying to interpret the law of the occult. And so this is a tempting thing for a lawyer to say to his client. Because what client wouldn't want to hire outside counsel and spend a lot of money on something that's as difficult as the law of the occult? The problem, though, is that it's not true. It has inculcated and cultivated this mystery about spectrum, that it somehow is different than other things to which people have rights, whether it be minerals, and whether it be water, perhaps because the latter are tangible and the airwaves travel through the ether and they're more ethereal. And perhaps that was true in the 1920s, but I think it has become less true now. And that misconception has been at the heart of the kind of very indeterminate rights to spectrum that we have today. You said fuzzy. Somebody said quasi. The fact of the matter is that there are no property rights to spectrum today under existing jurisprudence. Judge Doug Ginsburg has said that. The Supreme Court has not said that. If that were to change, and it may be possible to change this by changing the precedent as opposed to changing statutes, a lot of the problems that we've discussed would start to be solved. Harmful interference could be viewed also in terms of the extent and its intrusiveness as a taking issue, if we're talking about property rights. The inefficiency of the government would start to be thought about as being due to the lack of property rights that are being paid for by the users, whether they be government or private users, of the spectrum. And the interesting thing is that the first thinkers who thought about auctioning the airwaves thought about giving the auction winners property rights. Very few people know today a congressman called Henry Royce, who introduced a bill in 1958 to auction broadcast licenses. And then, of course, there is the seminal piece by Professor Coase in 1959, which first talked about auctions. Professor Coase was clear. There should be property rights, and federal spectrum should be also the subject of property rights for which the government should pay. Then in 1996, I wrote an article called Money for Nothing, ? Auction winners paid a lot, but what they got is not clear. And this article has been viewed as prescient by my wife. But it's not exactly seminal, because it hasn't inseminated anything. But I do think that the change of the law that says spectrum rights are not property rights in one fell swoop would result in remedies for almost all of the issues that have been being discussed. Satellite.
Yes.
Could you repeat the question?
Sure. I was actually going to start with Joan because I was hoping to get a little controversy at the end of the table here about how efficiently people view satellite as being, how efficient a spectrum user is satellite. Either one of you can take it first.
Me?
Yep, sure.
Well, I mean, I think we've seen the market address this a little bit, and market forces will work where they're capable of working, and there's a lot of things, a lot of regulations that stop market forces, and a lot of very specific allocations that stop market forces. For example, broadcasters must broadcast. They can't do anything but broadcast with their licenses. But what we saw with satellite, we saw at one point enormous allocations for satellite. Someone else is going to know how many, but tens of megahertz were set aside for satellite. We saw multiple satellite companies out there, but we did not see a proliferation of satellite services. And so what happened over time is those companies themselves, most recently Dish, bought a bunch of satellite, spectrum that was specifically allocated for satellite services out of bankruptcy. Again, market forces, certain satellite companies, including TerreStar, ended up in bankruptcy. Dish bought the spectrum for relatively cheap out of bankruptcy, went to the FCC, and had it reallocated for terrestrial use. So, I can't really address satellite businesses and how the existing businesses use how efficient they are with their spectrum. But we do know that there's a lot of businesses that couldn't make a go of it. And then through bankruptcy, the spectrum was reallocated. And it should be. I mean, I think it's great when we can use either legal forums or regulatory forums or other ways to reallocate spectrum to a better and higher use, and people can get more value out of it. And we are seeing that, I think, with multiple of the satellite bands.
Do you think it would have been better to have just given the old satellite providers full flexibility from the start? If you want to do a satellite service, fine. If you don't, that's fine too. Do CMRS.
I personally do, yes, because I do think that, again, the spectrum will find its best and highest use. The political concern about that is always the windfall, because the satellite providers, and I'm not an expert in satellite, so you'd have to go back to when they originally got their allocations, but value was paid at the time of those allocations, and the value paid was consistent with it being used for satellite. As soon as you reallocate that spectrum for terrestrial use, the value of that spectrum is going to blow up exponentially. So just to give you a sense of this, broadcast spectrum as broadcast spectrum, and Brian's going to correct me if I'm wrong on this, around 25% or 25 cents per megahertz pop?
Yeah, roughly.
So let's say 25 cents per megahertz pop. That same spectrum, you put it in an auction and you sell it to the wireless industry, and you can pick where you want to go, but let's look at the last major auction, over $2 per megahertz pop. That's a huge spread. And so I think politically there's always been concerns about windfall. If a certain person took an allocation and paid value for that allocation, consistent with how it was designed, and then magically they can wave a wand and change it, the value of the spectrum will go up a lot. And should that person get the windfall, or should the windfall go to, or I wouldn't even call it windfall, should the delta go to the U.S. Treasury?
Well,
And in auctions, that's what happens.
and it's you buy land to build a house and suddenly it's rezoned for the shopping mall, or you buy land and suddenly discover oil on it. Suddenly there's a windfall, and trying to figure out where it goes. Pantelis, on this point?
Yes, so first of all, when we ask and talk about satellite, there's satellite and there's satellite. There are so many different satellite bands. There are so many different satellite services. Most satellite bands are in what you, John, would call the boonies, or Siberia, as far as mobile terrestrial broadband is concerned. So they're not part of this conversation. Some satellite services are very efficiently using the spectrum, and you're correct that some are not. And I agree with you totally that the market can lead to solutions, and that this is a case in point. On the windfall point you raised, I might sort of gently disagree. Not that it's not necessarily a concern, but perhaps a more attenuated concern than I thought you were presenting it as. And the reason for that is, well, first of all, in the case of Dish, as you know, the assets were purchased out of bankruptcy, so as the FCC confirmed, there was no windfall. But more generally, if we are to start talking about windfalls, the number one candidate and target to look at is, of course, the broadcast spectrum. And under current law, there's no provision for the government getting a very significant portion of that windfall. So if there's going to be a dialogue about windfall, I think it will probably need to start first with the waterfront broadcast spectrum.
Yeah, and to be clear, I view this as a political question. We want spectrum, and we'll pay whoever wants to sell it to us. We don't get all that interested in whether they're making a windfall or not. To be very specific, we paid a whole bunch of people a lot more for spectrum than they originally got it. And so that's not really a big issue for AT&T, but I certainly recognize it's an issue that others, including those on the Hill, Congress, or the FCC, need to worry about and need to take care of from a political perspective.
So Rob and Bob, do you want to comment on, well, any of that, or whether, I want to try and point a discussion on whether or not there are adequate rules in place to make people utilize this resource fully. So one of the things the FCC has put in place and encouraged, not unlike the mineral rights discussion we had earlier, is build-out requirements, for example, presumably because they think that Joan may not have, or Pantelis' clients may not have the right enough incentive to build out based on the economics of the acquisition in the first place. Are there enough incentives in place? Are build-out requirements a good idea, Bob or Rob?
I think they're a good idea, and you've got to scale them properly. But in the past, I mean, it has resulted in quite a lot of unused spectrum coming back and being repurposed to other licensees and sometimes for other uses.
But those mostly in cases where the spectrum was acquired for free, I believe, in terms of spectrum being given back when people failed to be built out.
Not always. I mean, there's some cases of auction spectrum that came back.
So I'm sensing a little bit of dangerous agreement on this panel, so let me try to poke a
Yes,
hole in that
I've
a
been
little
trying.
bit.
I've been trying.
So I think we all seem to be agreeing that the necessary precondition for inefficiency is a lack of flexible usage rights to spectrum. And I think the disagreement may come where, what do you do about it? So in the case of commercial spectrum, there's maybe one set of solutions and another set of solutions in federal spectrum. And this, I think, also relates to your point about efficiency, Brian. So there are probably a couple different approaches to driving highest use of the spectrum and greater efficiency. One is sort of passive management, I'll call it, and I think of that as just setting the economic conditions for the spectrum to be used in the highest way. So providing some level of property rights, whether that is a legal matter or not, maybe charging some fees for spectrum usage, ability to sell, lease, and trade spectrum rights. All those things can and have encouraged efficiency in the commercial context. But it does assume that the people involved in those transactions are economic actors and responsive to economic incentives. I don't think that's necessarily the case in the federal context. So I don't think what I'm about to say is mutually exclusive with the set of solutions I just laid out, but I think there's also a set of what I'll call more active spectrum management approaches that we should be thinking about in the federal context. And it does involve greater top-down scrutiny rather than just setting the conditions for an efficient market. And I think one of the big problems at OMB I saw when I was there is that spectrum was this very esoteric issue. No one really understood it or thought about it. And that's the case, I think, throughout the capital planning process in federal agencies. When the Department of Defense or any other federal agency is making a big new investment, they think about all the capabilities it needs to do. They think about the things they need to pay for, the number of bullets that's required, et cetera. But they don't really think about how efficient the wireless system is. So raising the profile of spectrum in federal capital planning is a good idea. And also, I think there is room for periodic reassessment of spectrum use. What always struck me as interesting was the BRAC process, the base realignment and closure process that Congress does every few years. David probably knows more about it than I do, but it seemed to me that something like that can be useful in the federal context where it's not just an agency got a specific authorization for spectrum decades ago and has never been revisited in any meaningful way. But if there is greater scrutiny in that regard, I think we probably find that turning over those stones is actually pretty fruitful.
Is scrutiny enough, or there's just need to be incentive pricing or some other economic mechanism?
So I think that can work. It needs to be designed smartly, though, because of the lack of true economic incentives in the federal context. And what I mean by that is, if you have a fee for federal spectrum use, so the Department of Defense needs to pay for the frequencies they use every year, just like they do for rent in the buildings that they occupy. There's an element of just sort of a money go round here, right? So it becomes part of their budgeting process. It becomes part of their base costs, and it just gets worked into appropriations every year, and it's not really meaningful, at least as meaningful as it could be if it was a true cost. So not saying it wouldn't be useful or it's not possible. We just need to think about those dynamics.
So I'm not sure you got to controversy there, so let's see if we do. Did any of the panelists disagree with anything Rob just said?
I did not, even though it was billed as a disagreement.
Exactly. It's very overpromised there. So does anyone have other? So the basic premise here is like federal government spectrum users don't have any incentive to use it efficiently, unlike the economic incentives that are involved in the commercial side. There is a larger dialogue underway right now about what sort of incentives should be promoted among federal users. The Office of Science and Technology Policy has sought comment on a series of proposals to create certain incentives. There are bills on Capitol Hill that look at additional incentives for federal government users. Any additional comments on what kind of incentives might be effective for federal users?
I personally think this is a very, very difficult nut to crack, to be honest with you. I don't think sticks will work for the reason I agree with Rob. I'd like to disagree, Rob, but I just can't. It's going to become a budget item, right? You put fees on there, you put whatever financial requirements on the spectrum. I think it just becomes a budget item. and it gets lost. So I tend to think that there's probably more opportunity on the carrot side. And what we see with a lot of federal systems is for them to evolve to new technologies, they do need money, and they need budget to do that, for them to buy new systems, do new deployments, et cetera. I also think there's opportunity for some, not all, but some services to migrate to commercial services. So they could have, and we are a big provider of wireless services to the government. So some of the government uses probably could be managed on commercial platforms. And so I think, I view it more that there's got to be an opportunity for them to have some meaningful economic carrot, where if they surrendered their spectrum, and certainly with the item that was just adopted at the FCC last week, which is called AWS-3, that's exactly a situation where government incumbents are in certain bands. They are going to leave and relocate, and those bands then are going to be made available to the wireless industry for commercial uses. With the deal that was struck, and this was not easy because incumbents don't like to leave their spectrum bands, the deal that was struck was they will get all their relocation expenses paid. And hopefully that will include new systems, new networks, et cetera. So they'll get updated systems out of it. They'll have all their expenses paid. Even then, they were very concerned that that would become money that just moves around and they would never see the bottom line. But I think they've worked through the hill to get assurances that when that spectrum is sold, the money received from the wireless industry, a significant part of it will go right to the incumbent government agencies to pay for their relocation. So I view that as a more effective incentive than trying to figure out how to put monetary penalties on them.
I agree with that, and I would add that there is significant experience in the private sector doing relocations. Sometimes they cost a few billions more than originally budgeted, but the precedent is there and the experience is there. And I agree, John, with your carrot versus stick approach. Also, Brian, on the other prong of your question, which had to do with incentivizing the private sector as well, and build-out requirements, I would agree that those are sensible, with, of course, some important caveats. They do need to be realistic, because if you have, and we've seen some of those, breakneck speed, unrealistic schedules, such as the one, for example, that was imposed on SkyTerra LightSquared, of course, it was the least of that licensee's problems.
Right.
They do not achieve any purpose, either in the interest of the licensee or indeed in the public interest. And also, there needs to be a more cohesive enforcement of build-out schedules. By that, I do not mean that they should be enforced rigorously and to the letter, so that a day's delay would cause a license forfeiture. The Commission should acknowledge a fair degree of flexibility, but that flexibility should be applied uniformly.
I thought it was interesting because the last panel talked about the terms of rights expiration being, if it was too short, it disincentivized the right kind of investment. And I think there's a very interesting parallel here. Joan, do you really need build-out requirements? You spend billions of dollars on spectrum. Is it really some risk that you're just going to sit on it?
We're not going to sit on it, but this is why we like build-out requirements. There are those that will sit on it. And when the build-out requirement comes up, they are the ones that want to sell their spectrum. It is a very efficient mechanism to force secondary market transactions. And a significant part of our portfolio has come from secondary market transactions. So no, we have every incentive to build. Now, very often we're accused of sitting on it. For example, in 2008, with the first digital TV transition and the first 700 megahertz auction, we bought significant licenses there, and we didn't build them immediately because they were the licenses we had reserved for next generation technologies. So we were waiting for those technologies to mature. You have to do spectrum planning. You have to do short-term and long-term spectrum planning. So I agree that it can't be unrealistic build-out requirements. You have to give people a horizon to put together a rational plan. But for those allocations, we would have had no place to deploy LTE technologies. And because of that auction, because of our ability to buy spectrum there, as well as other carriers' ability to buy spectrum there, the United States is the leader in the deployment of LTE fourth-generation technologies. So, but those licenses, without a doubt, came with build requirements. And so they're serious build requirements. We've met them. We've already, a significant number of them have already come due. We've made hundreds of build showings now with those licenses. But more importantly, for those folks that aren't serious about building the licenses, those build requirements, and particularly those benchmarks, will force them to reevaluate whether they're going to continue to hold the license or whether they would rather sell it and monetize it. And we're all for anything that incents an efficient secondary market.
Bob, what area of spectrum reform is most ripe for reform?
Well, I mean, we talked about sharing, and there's an obvious premium on opening up some existing allocations to sharing, and there's a need to do that. I think there ought to be some thought given as you do that to what sharing really means. And when you look at, just for example, the case of the unlicensed devices, I think what most people find to be a bit overwhelming is that you're being asked to share your spectrum with 15 billion devices. I mean, it's like sharing your apartment with your cousin and 300 of his best, closest friends. I mean, you got to get your arms around that. And so I guess to answer your question is, I hope that as we pursue sharing and some of the other issues that we're talking about, that there isn't a lot of wishful thinking that goes into it. And I think sometimes the temptation is that it becomes an easy answer and a substitute for making hard choices, whatever the right policy outcome ought to be, perhaps ought to be discussed.
Rob, most needed for reform?
So I'm actually going to take the converse of that question and just talk about what's worked really well that surprised me. Because I missed this early on, and that is really around unlicensed spectrum as really a platform for wireless broadband. And that's something that I certainly discounted as early as 5 years ago because of the lack of true rights in terms of the protection from interference that unlicensed spectrum and Wi-Fi has, which is little to none. But as we've actually seen, it's become this huge, Bob just mentioned 15 billion devices. I'm not sure it's quite that many, but it's a lot. Wi-Fi carries the majority of internet traffic today. So it's really crucial to the nation's wireless broadband goals. That's something that I didn't necessarily foresee all that long ago, and it's really been driven by a dynamic where you have a set of economic actors in that space, regardless of not having rights, the incentive to cooperate together to make that spectrum useful. I'm talking about the IEEE and the Wi-Fi Alliance, developing a set of protocols and capabilities for the technology that works well. And I think it's been a little bit surprising to me. And to David's point earlier, that isn't necessarily always going to be the case because of the lack of interference protection. There is the possibility for an interferer to come in with little recourse for the huge Wi-Fi ecosystem that exists today, other than writing their congressman. So that's something that I certainly worry about. I see it as not necessarily ripe for reform because it hasn't been a big part of the policy discussion yet, but I think it should be. I think just because the policy framework in which Wi-Fi grew up didn't anticipate it, there's been an almost discounting of the rights and the importance of Wi-Fi and unlicensed spectrum. But if you think about it from the consumer perspective, let's not let the tail wag the dog here. Everyone really cares about Wi-Fi. No one's ever heard of Skyterra, just to pick a random example.
Progeny, so we're saying, yeah.
Progeny, yeah. So let's just keep that in mind as we think about this.
So is that reform essentially? You would say, look, the commons have worked well. Much as you have a national park that's declared off limits forever for common use, you would say 902 to 928, 2.4 to 2483, 5 gig, permanent, unlicensed regime, and they are afforded interference protection.
Maybe. That might be one answer. There's a long way to go from here to there, and I don't know that's the only answer, but I'll tell you what gives me pause is the potential I just mentioned for something bad to happen to Wi-Fi is not just a theoretical example. There are new technologies coming online now that can actually pose a real threat to Wi-Fi. I'm thinking specifically about a nascent technology known as LTE unlicensed. And what this is essentially allows the mobile protocol, which is LTE, so all of our iPhones run on LTE. It's the protocol that AT&T and others use in the mobile space there's a way to do that protocol in the unlicensed spectrum. And the reason that could be a problem for Wi-Fi is because LTE is a scheduled technology, meaning it's centrally coordinated, whereas Wi-Fi is very polite. Anytime you're using Wi-Fi, your device is listening to see if there's an available channel before it transmits. So in the abstract, and in the worst case scenario here, there's the possibility for LTE to essentially just schedule itself continuously in unlicensed spectrum to the detriment of Wi-Fi. So, that's something that I think needs a little more exposure and discussion about what that means in spectrum policy.
Joan, area for reform?
We've talked so much about some of the areas, in particular as it relates to government incumbents. So I'll sort of try to take on a different area and based a little bit on our experience with some bands. I think that there is a real need to relook at interference claims and the battle of the interference. And we've seen some victims of these battles. I think Light Squared was addressed, where one company was trying to deploy a terrestrial network and take underutilized spectrum and fully utilize it for a terrestrial network. But they were adjacent to other users who made claims that if they did what they said they were going to do, it would interfere with their incumbent systems. And that was just very, very challenging to watch that play out at the FCC. And we've been engaged in some battle with interference claims as well. And the problem, I think, with the current regulatory regime is there's not clear definitions of what constitutes harmful interference. And understand there's always noise. You don't operate a radio system noise-free. The question is, when does that noise rise to a level that it's creating harmful interference to you? And the FCC's processes tend to get very politicized. And they are very loath to rule against incumbents who have made investments, et cetera, et cetera. So I think there's been some dialogue about how do we make these claims managed in more of a forum where you have a judge or an arbitrator who's an expert in these areas and can resolve these claims based on science and physics and not on all the other stuff that can come to bear when it comes to claims about harmful interference.
So I want to come back to enforcement because Dale's here and it's near and dear to his heart. So I want to make sure we get a full round on that in a second. But Penn, tell us what's our area for reform for you? From you?
Interference is a good one, and I have some.
There you go, agreeing with Joan again. I don't know what we're going to do with you two down there.
I have some good thoughts and a slightly different thought. If the claims court had jurisdiction in the battle between Light Squared and the GPS industry, you might get some meaningful and interesting results. So that goes to the whole issue of whether property rights should be recognized to the spectrum, because as you know, this interference question hinges on some alleged squatting, right, on other people's spectrum. And as far as enforcement is concerned, right now my understanding of the law on harmful interference complaints is one of exclusive jurisdiction, perhaps, of the agency. It might be useful to consider a regime where there is court jurisdiction with the agency having primary jurisdiction. And where perhaps our paths diverge, John, is the expectation that the court will have the expertise, because that may be unlikely. But giving the agency the primary jurisdiction will allow it to comment on the technical aspects, but not weigh so heavily on the political aspects, and then let the court decide. And another quick point I would make, Brian, is on permanence. I would caution against permanence of any spectrum reform because the assumptions are time limited. So there's a tug of war between the spectrum that is available and the content that needs to travel through it. And right now, the spectrum may be scarce, with Netflix movies trying to squeeze into it. And for the next 5 years, there may be this persistent and increasing scarcity of the spectrum, which will militate for one kind of spectrum reform. Then there may be spectrum efficiency innovations that will change this tug of war and make the spectrum less scarce and perhaps content more so.
Now, Bob, you seem somewhat skeptical of this court idea, despite
Yeah,
the
well,
obvious,
I mean,
obvious
look, I'm
collectible
sorry, and
opportunity.
I'm a lawyer, and, this is what I do for a living, so please understand, but boy, I hope the answer to interference isn't take it to court. I hope we can find better ways of dealing with it than that, and of course, if you have a really big case like a light squared GPS, and we weren't involved in that, and honestly, I'm bothered by the outcome in that, but maybe that's just me. I think you have to find other ways to deal with smaller issues, because I think you have a lot of smaller issues than one big band conflicting with the GPS network.
So I think the institutional concern, right, is the FCC is a relatively small agency. It has 16 field offices around the country staffed by a handful of people. If you're actually asking them to be the enforcer throughout the United States, are they really the right place to do that? And are they, especially as we become more congested?
Well, and what exactly are you talking about when you're talking about an interference issue? I mean, if you're talking about licensees that are operating lawfully and they happen to be causing interference to each other, notwithstanding their lawful operation, I had a case like that. It went 7 years.
Yeah.
No, and by the way, we had 3 decisions. We were ahead 2-1, and it ended when Nextel bought both sides.
Interesting marketplace resolution.
Right. I just think you got to find other ways to do this. Maybe some of the technology can help. Maybe you can have priorities written into some software that say this type of communication gets a higher priority than that type. That's one of the things they were doing in the DSRC spectrum band.
So I want to throw it open to outside questions, but I want to give Rob one quick chance on this enforcement matter. If you can say courts, FCC, somewhere else.
I'll go out on a limb here and say that the answer to harmful interference is not to make it more lawyerly. I think it needs to be.
What do you mean? Now I will disagree.
So here's the controversy. Okay. So adjudication takes a long time. The issues are highly technical. I think this is what Pierre and Phil have tried to address with part of their work on spectrum reform through what's called harm claim thresholds, essentially defining interference in advance in order to provide more predictability and sort of a less room for arbitrage and gaming in the FCC process. But I will just say, while that holds some promise, that really raises the stakes in terms of upfront allocation, right? Because you don't want to set a harm claim threshold for a certain service that makes no sense 10 years down the line in terms of the highest use of the spectrum.
Questions from the audience, students first, if possible. Yes. Amber, right?
Hi, thank you for coming. This may be too broad of a question, but what is the government hoping to achieve from the upcoming auction, and what is the private industry, such as AT&T, hoping to gain from this auction?
So I'll take the easy part of that question first. AT&T hopes to get more spectrum. Because there's just not as much spectrum as there is out there. There's not a lot available for commercial use because we're to an inflection point where most spectrum has been assigned to incumbents and incumbents are hanging on to the rights. So it's this type of an auction we view as an enormous opportunity for us to, in the entire wireless industry, to get more spectrum, which is very badly needed to continue to serve our customers. What does the government hope to get? I think the government hopes that they will show that this type of two-sided auction, where some come to participate to surrender spectrum and some come to participate to buy it, to work. That economic incentives can come into play here, and when you provide an economic opportunity for an incumbent user to surrender their spectrum and get economic value, that they will participate and they will try to achieve that value. And they also hope to raise enough money not only to clear the spectrum to reallocate it, but also there's a part of the Spectrum Act empowered FirstNet. And you'll all recall after Katrina, what came to bear, what we all discovered was all of our first responders can't talk to each other. They were not interoperable with each other. They were all on their own unique proprietary networks, and so the local guys couldn't talk to the state guys, couldn't talk to the federal guys. FirstNet envisions a nationwide interoperable wireless network where all first responders can talk to each other, and the government hopes to fund that in part by spectrum auctions, including the next AWS-3 one, and as well as through this. So I think there's multiple goals that the government hopes to achieve, and deficit reduction. If there's any money left over, that's always an important goal as well. So I think there's a lot of priorities for the government in this if this all works.
We have another question over here.
How does the spectrum regulatory regime in the United States Europe, Asia, maybe more aggressive than ours, or not?
So the question, in case folks in the back didn't hear, is compare and contrast the U.S. Spectrum management model to Europe and other countries around the world, Europe and Asia, perhaps.
Maybe I'll just take a quick crack at it. First thing that comes to mind is each country in Europe has their own national regulator, whereas in the U.S. we don't have state-based wireless communication regulators. So in that sense, the U.S. is, I think, a little more conducive to predictability and consistency. In addition, in my experience, the U.S. has tended to be the first mover in making new spectrum available. So certainly our neighbors tend to look at what we do very closely and see if they can follow our lead. And since the global market, or the market for wireless communications equipment is global, that tends to drive the agenda in other jurisdictions as well. So, I'm not sure about the more progressive versus less, but those are some of the differences I see.
And let me add that all of those regimes are subject to the ITU, International Telecommunication Union, radio regulations, which has allocation rules about which band should be allocated to which service for essentially the entire world. So that's a common factor. And of course, within that regime, each country regulates and licenses its spectrum in different ways, including by auctions. One piece of information that you, John, on behalf of AT&T might appreciate is in New Zealand, the first auctions that were done were so-called victory auctions. Those are auctions where the winner, the high bidder wins, but he doesn't pay his bid. He pays the second highest bidders win. But the U.S. has not adopted this format.
I think the only two other quick observations about that is that I think we have many more incumbent users because we've tended to be first in a lot of fronts. So we probably devoted more to TV than other countries did generally. We had more devoted to military, which are two decisions that we're now trying to solve for because we invested in those technologies early. Another question over there? Yep.
Curious about what your thoughts are on the forthcoming Supreme Court case for Aero and kind of what changes to be seen for regulation with cloud-based programming in the future and implications of that.
That screams Pantelis to me. Go ahead.
It's a tough case. It really has no direct implications for spectrum reform as such, but it does have huge implications for copyright and retransmission consent. And you have Aereo, an online distributor, saying that it doesn't need retransmission consent and it doesn't need copyright to do what it does. So if the Supreme Court were to side with Aereo on the copyright side, there may be a lot of controversy about whether, in fact, online providers do need retransmission consent, just like other distributors. If the broadcasters do lose the Aereo case, you would expect the broadcasters to flock to Congress and request that the satellite home viewer reauthorization law, which until now they thought should be a clean reauthorization, you would see them arguing in favor of it becoming a much broader piece of legislation. So those are some of the issues.
And I think it's just a really interesting example of new technologies and new business models colliding with old spectrum allocations and old ways of doing business. I think it's a fascinating case. I'm watching it personally. I haven't really decided where I think the chips should fall, but it has, I think, I agree with Pantelis, not huge implications for spectrum or spectrum reform, but enormous implications for the broadcast industry and all the other regulations that attach to that industry.
So I'm afraid that's going to be our last word. I want to thank our panelists for a great job. We have a 10-minute break, and then we'll be back in here for the next panel.
Thank you, John. Great job. Let's have lunch one day.
We weren't as controversial last time.
No, it's appointed. But we live